I'm going to talk about the billable hour. Now, why in the world would I want to talk about a topic as boring as the billable hour? Well, I am a litigation attorney. I do business litigation at a commercial and business law firm. And every day of my working life is subject, from the beginning of the day to the end of the day, to the billable hour. Now, I am quite happy with my job, but I tend to believe that we'd all be a bit happier if we weren't so subject to the controlling power of the billable hour each and every one of our work days. So I'm interested in alternatives, and I'm interested in how we have to change our thinking as a profession in order to embrace those alternatives. And that's what I'm going to talk about today. So let's dive in. First of all, what is the billable hour model, in case you haven't seen it before? Well, it's an approach to legal work that cuts your life into little 6-minute increments. Every 6 minutes is called a 0.1, 1/10 of an hour, and an attorney will create a billing record like the one you see at the bottom of this slide here that shows the work they've done for a client, the amount of time they've spent on it, their hourly rate, and those two numbers are just multiplied to get the amount that the client pays. The client receives a bill that looks something very much like this at the end of every month or so, and they pay the bill. Lather, rinse, repeat, and that's how a law firm is built, right? And so for associate attorneys like myself, the law firms expect us to hit a yearly target of a number of billable hours that we must bill each year to essentially justify our positions. And in most law firms nowadays, the median billable hour requirement is somewhere between 1,800 and 2,000, which is quite a bit. So why does the current model have such staying power? What is it about the billable that's made it stick? Well, for law firms, it's measurable, right? It's a simple multiplication equation when it really comes down to it. And that simple equation can be scaled to a large department, and it can be used to predict profitability and make projections and manage budgets and things like that for the firms. Clients like it in some ways, not in other ways, but clients like it in one way because a client who's not a trained attorney can look at a bill and say, oh yeah, that attorney spent an hour on that task, spent a half hour on that task, that seems reasonable, that seems reasonable. Hey, why did they spend 3.5 hours reviewing a document, right? And the client can sort of review and have a conversation with the attorney about the bill. So in addition to law firms and clients, I think there's another influence on the billable hour that doesn't get addressed that much, and it's the influence of the courts. Right now, courts are often called upon to award attorney's fees to the prevailing party. The losing party, in some cases, has to pay the winning party's attorney's fees. And as part of that process, the the court has to decide what the reasonable value of those attorney services provided were. How does the court do that? Using what's called the lodestar method, which is essentially the billable hour model. They look at the number of hours the attorneys have spent, they look at their hourly rates, and they make a decision about whether that's reasonable, and they adjust it up or down if they don't think that it is. So what this means is that nearly every litigating law firm, even law firms not based on the billable hour model, usually have to track their time. Because if they don't track their time, they're not going to have anything to submit to the court when it comes time for them to get their prevailing party attorney's fees. So the courts are also going to have to evolve a little bit if we're going to be able to move beyond the billable hour model. Now, I put a diagram up here. I'm not going to go through everything in detail, but I just wanted to give sort of a broad visual of how the billable hour model is measurable, predictable, and scalable. It's all based on this simple multiplication equation that you see in the middle here. And from there, all of this different analysis that you're seeing here can be done with simple 4-function arithmetic: add, subtract, multiply, divide. You don't need a lot of fancy statistical regressions. You don't need to integrate or do derivatives or anything crazy like that. It's all just really simple math to help you understand how profitable your firm is, how you can safely grow, and things of that nature. So the billable hour creates a culture, obviously. It creates a culture where time is money, quite literally. And it's not surprising that that culture also creates a lot of burnout, because if the sole way you're being valued is based on the time you put in, then it's going to be easy to burn out, and burnout is even going to be embraced in many cases as a rite of passage. It also creates an internal hierarchy within firms. It increases an attorney's sense of self-surveillance. Why am I not working? Why am I not billing right now? That kind of thing. And firms encourage this rather than discourage this. There are some firms that use scoreboards. They put a scoreboard up that says, here's the top people who's billed the top number of hours in the past week, which it really just only reinforces this billable hour culture that we're talking about. So with an understanding of what the billable hour is, this brings me to my big idea. And my big idea is pretty simple. It's more just about a mindset shift. If we, as a profession, can shift away from valuing attorneys based on time to valuing attorneys based on quality and results, that will help us move beyond the billable hour. And what is enabling that? As we speak, tech and AI and generative AI and large language models, all of these things are enabling this shift to take place as we speak. So a good place to explore this shift a little more is by inquiring into what we call alternative fee arrangements. These are business models that are alternatives to the billable hour. Each of these exists already in the legal field. They've been tried, they've been used, but none of them is nearly as prevalent as the billable hour. The billable hour is still the primary model that attorneys use to value their time. And I've ordered some of these alternative fee arrangements from top to bottom. The ones toward the top tend to be more valuing the attorney's value according to the time that they've spent, whereas the further down you go on the list, these different alternative fee arrangements tend to place more of a value on the results achieved and the quality of the work. And two of my favorites are the two lowest ones here in the list. A true flat fee. So for example, I'll prepare your complaint for you. Our firm will do all the research, file and serve the complaint. Rather than charging you by the hour for that, we say, okay, this will be $5,000, this will be $10,000, whatever it is based on the scope of the project. A true retainer is essentially a subscription model where a client says, I will pay you, firm, a certain monthly fee, typically a monthly fee, for the firm to take care of all that client's litigation needs, or perhaps all that client's litigation needs of a particular type. So these are some of the alternative fee arrangements, and the big question then is, how are tech and AI and generative AI and large language models enabling us to start considering some of these alternative fee arrangements? I think the most obvious one, the most obvious observation is that it's helping to reduce workload for a lot of tasks that used to be really, really time intensive. There's time intensive tasks in a firm such as document review and discovery responses and creating compilations, going through bank records, going through medical records, hundreds or thousands of pages of them. And until somebody's gone through them, you don't know which ones are important and which ones aren't. AI is helping to cut down on that, the time that's needed for things like that. And what that allows firms to do is more profitably offer flat fee and other type arrangements for things that used to take a lot of time and need a lot of customized work. Project management is also another area that's helping us to embrace new models here. When you have a LLM or some sort of AI implementation that can break up and delegate and track very large tasks, very large projects, you're able to manage scope creep. The firm can offer a better fee. The client can know that they're getting a better deal. And the third idea here is that better data equals better pricing. And I really like this idea, so I wanted to give an example of what this kind of looks like. So for those of you who know some statistics, what I've created here is two examples of a hypothetical normal distribution curve. And we're looking at a situation where, for example, the client needs a summary judgment motion drafted for one of their cases. And the client and the lawyer are talking and trying to agree on a fair flat fee for that summary judgment motion in advance without knowing exactly how many hours it's going to take. So the idea is, if we go back to previously existing cases, if we find cases that are similar to our current case, we can look through the records of the case and get a sense of how much workload it took to bring that summary judgment motion through to completion. And the idea is we can do an analysis and hopefully get a fair rate for what that would be. So the top here represents our situation when we don't have LLMs and we don't have a way of doing a large data analysis of a lot of different data points. Because these normal distributions require us to have a lot of different data points. And unless we can somehow look at thousands or tens of thousands of cases, it's just not going to be possible for the firm and the client with any sort of certainty to say, yeah, this motion will take about $10,000. This motion will take about $20,000, maybe a little bit more. It's probably going to be difficult for the firm and the client to agree on a price because there's no objective standard there. And the bottom shows what happens if we do have some tech and AI. If we have an LLM, for example, that can spread out over all the case law from all the trial courts across the country, find the cases similar to ours in different ways, and do an analysis. How much briefing was required? Was additional briefing put into play? Was there a hearing? What happened after that? All these different things. We can cross-reference that with the judge in particular. We can run all of that judge's stuff through an LLM and say, how does this judge typically rule on summary judgment motions? Do they generally tend to create more work or less work for parties? So using that information, we can then arrive on hopefully what we think is a fair flat fee here. And then from there, the attorney and the client can negotiate higher or lower. A risk-averse client might be willing to pay a little bit more to cap their liability, and the competitive firm might be willing to charge a little bit less to undercut a different firm. So let's bring it all home. What does this all matter, right? We've got AI implementations. We're moving beyond the billable hour. What does this mean for our profession? What does this mean for the rule of law? Well, one of the really important things right off the bat is these LLMs and these AI implementations are going to really help with educating the population and providing access to justice. And the reason that's important is because of this particular statistic right here from the Legal Services Corporation that says that 59% of Americans who experienced a civil legal matter within the past 3 years did not seek out legal help from an attorney. And a lot of the times the reason that's true is because folks don't know that they have a legal claim. All they know is they've got some sort of dispute, something went wrong between themselves and some person or some company, and they don't think to call an attorney. So what I think is amazing is even right here, right now, as I stand here in 2025, we've got ChatGPT, right? You don't even need an account. You can go on ChatGPT right now. You can type your situation, couple paragraphs into ChatGPT, ask it for a basic analysis of whether it's worth it to go talk to a lawyer, and it'll give you something really good. Well, maybe not, but that's why you have to go to an attorney, right? But the point is, it will at least help you get out the door a little bit, right? And just like in the past, we had blog posts and things in firms, none of those things were substitutes for actual legal advice, but the point of them was to help people understand if they did have a claim to begin with, and then to go to an attorney to talk about what they might do to assert that claim. So that's how it's helping to educate the population and provide access to justice. Another area is democratizing legal expertise within firms. Now, what do I mean by this? I think another area where there's a lot of inequity in the profession is in how new lawyers get trained within their firms. Mentorship is not always a structured system. It's often unstructured and just sort of happens with informal relationships. And what happens is that can replicate both individual and systemic biases, right? People who are already in the in-groups are getting the best mentorship. People who are not already in the in-groups are getting left out a little bit. So the idea here is imagine a world where AI implementations can analyze a new attorney's work product, figure out exactly where their strengths and weaknesses are, and generate custom MCLEs, custom training modules to help bring that attorney's skills up to par with the rest of the attorneys in a department. And I think that's pretty exciting. I think the mental health improvements, or the potentials for mental health improvements, are also very exciting here. I don't think it's a surprise to say that the billable hour model creates burnout. And we also know that burnout is a phenomenon that disproportionately affects minority attorneys, women attorneys, caregivers, folks that don't typically tend to fit the traditional lawyer mold. I think another thing for mental health improvements is it also helps us as attorneys to perhaps balance out the use of our right and left brains a little bit more, right? I think a lot of these tasks that AI can already automate are tasks that were very right brain heavy activity that involved a lot of logical, rational thinking and that took a lot of time. Well, if we can move beyond that and contain that workload a little bit, we free up attorneys to use their left brains a little bit more on client management, on strategy, on more of these overall things. And I think the idea is that if an attorney can have a little bit more balanced use of their mind and their abilities in a given day, week, year, that's going to help with mental health in the profession. And finally, we're talking about how AI will help challenge outdated hierarchies and open the doors to a more diverse workforce, right? So under the billable hour model, success is about long hours, rigid time tracking. Innovation is not incentivized. If you do something faster under the billable hour model and more efficiently, it means you earn less. So, I think to a lot of us that doesn't really make sense, and there's not a lot of space in that model for lawyers who think differently and contribute in non-traditional ways, right? So many neurodivergent lawyers will struggle with having to clip their life up into little point ones, very clearly switch between one task and another, and bill their hours that way, whereas these new implementations we're talking about are more optimal for brilliant legal minds who might not otherwise thrive in the billable hour system. So that's what I've got for you today. In closing, I'll leave you with this final thought. The billable hour taught us how to measure time. Technology is teaching us how to measure value, and that doesn't just make our profession more efficient, it makes it more human. Thank you.